I don't believe you heard me. Never fear, you did not miss anything. I was just giving a background on today's webinar. This is a part 2 webinar for our fair housing overview. Part 1 was about a month, you see right there on your screen. And so I will move ahead. So this is a lot of information today that we're going to be going through, and I'm going to do my best to go in depth into these subjects that you see here: reasonable accommodations, criminal records, Violence Against Women Act, hostile environment, and quid pro quo harassment, how to handle complaints. And then there will be time for questions. Also, there's, if you see on your GoToWebinar toolbar, there's a section where you can ask questions, so feel free to do that at any time. I do want to take just a moment to talk about Quadell. We are a management and consulting firm. Our headquarters is in Washington, D.C. We've been operating since 1978, and we provide an extensive range of technical assistance, training, consulting, and program management services to public housing authorities, state housing agencies, and private sector clients. On our website, if you're interested, we also do custom trainings in addition to all those services that I mentioned. So please feel free to peruse our website if you're not familiar. I myself am a senior associate with Quadell. I've been with Quadell for over, I guess, 3 or 4 years by now. And I have a total of over 10 years experience in housing, everything from recovery housing, solutions for the chronically homeless, permanent supportive housing, housing mobility programs for voucher holders, public housing, HCV, the list goes on, and obviously also fair housing, which is what we're going to be going over today. I will spend a little bit of time just talking about some of the basic tenets of fair housing that you will need in case you're not familiar. But again, for an in-depth background and history of fair housing, please view the first webinar, which is located on our website. So as we all should know, fair housing is the idea that every person has the same access to housing and housing-related transactions, regardless of their membership in a protected class. Fair housing laws, which we'll be reviewing today, seek to take down fences, and you see a picture of a fence there, seek to take down fences that keep certain people out of housing, the housing industry. And these laws protect vulnerable populations from unfavorable treatment for no other reason than who they are. The Fair Housing Act is the bedrock of federal efforts to end discrimination in housing and the blueprint for state and local legislation and efforts to the same end. And so a lot of what we go over today, those subjects I mentioned before, are all going to be based on federal housing laws. Fair housing laws. So we have discrimination and protected class. Discrimination is simply when you make a decision for or against a person or a household, on the basis of their membership in a group, class, or category. And those groups, classes, and categories we know as protected classes. And so we will briefly talk about those as they pertain to federal fair housing in a moment. One thing I want to mention is that, as I've said, we'll be discussing rules and regulations that come from the federal level, also state and local levels to fair housing laws. Communities often enact additional protections as needed in their community, depending on the types of actions, discriminatory actions that are going on in those communities. And if you're interested about those, then you want to look for a local or a statewide human rights commission or agency, which is often the one responsible for investigations, if not your state attorney general's office. Also, I recommend that you become familiar with local fair housing groups, which investigate claims of discrimination and also provide education, mediation, and other services in your community. As I mentioned before, the Fair Housing Act protects certain protected classes. We see the 7 here: race, color, religion, national origin, sex, disability, and familial status. The Fair Housing Act, this is the kinds of discriminatory treatment that the Fair Housing Act prohibits. refusing to sell or rent, discriminating in terms of conditions, advertising preferences, persuading owners to sell or to rent, also known as blockbusting, redlining, which was really a feature of mostly the mortgage industry. Other things that are prohibited we'll cover today: refusal to permit reasonable modifications or to make reasonable accommodations. That's prohibited by the Fair Housing Act. And as I said, we'll go over those more in depth later. Here are a few more ideas. Enacting unreasonable occupancy restrictions, that's considered discrimination against someone's familial status. We have 2 bullets right there in the middle that deal with harassment, which we'll go over more in depth again later. So again, a lot of this we covered in our first webinar, so go ahead and view that if you haven't. I do want to talk about the second bullet here, disparate impact. The reason that this is important is that a couple of the topics that we're going to cover later are really based out of this theory, this disparate impact legal reasoning, which prescribes the same kind of view to actions that might not be intentionally discriminatory but have the same effect. That building there is the Supreme Court building. A few years ago, there was a decision there that upheld the use of this disparate impact theory and kind of standard in considering fair housing cases. This was in 2015. The basis of this is that an act is considered to be discriminatory if it has the effect of discrimination regardless of the intent. Anyone enforcing rules which have a disparate impact, or meaning a disproportionately harmful impact on certain protected classes, you're subject to the same penalties under the Fair Housing Act as someone who intentionally discriminates. Okay, and so I have a couple quick examples there. If the first one deals with disparate impact against folks with who are maybe disabled or have some form of unearned income. The second one deals with familial status. And so if I'm charging your rent per person for the same accommodation, so it's a mobile home park, if I'm charging you the space where you park your mobile home, or if I'm renting, for instance, a mobile home, and they're the same size lots and such, but I'm charging a family of 2 one price and a family of 5 another price for essentially the same product, that's disparate impacting and will likely be seen as discriminatory. So I want to jump right into our first topic, which is reasonable accommodations. These are really popular. So when you look at discrimination complaints in housing, the #1 complaint is going to be it's definitely nationwide in most jurisdictions, all the jurisdictions that I've ever looked at. But I haven't looked at all of them, but in the ones that I've seen, discrimination against individuals with disabilities is the #1 complaint in terms of numbers, highest share of complaints. And one of the reasons for that is what we're going to get into today about reasonable accommodations and modifications. This isn't a part of the law that's maybe as widely known as just racial discrimination or gender discrimination, and it's a little bit more intricate and complex. But the first thing I wanted to do is lead with that first bullet, which really I should have put in bold. Reasonable accommodations are required under the Fair Housing Act, period. That's really important to start with because it'll make your job of avoiding reasonable accommodation based complaints a lot easier when you start there, even though there are a request has to meet certain criteria in order for it to be considered a reasonable accommodation request. And we'll get into that, but I just want you to hold on to that for the time being. And what's a reasonable accommodation? Look at that second bullet right there. It's a change or modifications in policies, procedures, and services that enables folks with disabilities to have access to the premises just the same way as anyone else in terms of applying, in terms of complying with the lease rules, so on and so forth. And one thing I want to point out is this protection against discrimination applies not only to individuals with disabilities, but also those that individuals associate with, household members, other family members, friends, etc. All kinds of housing industry participants, from managers and owners to condo associations, lenders, real estate agents, brokerages, etc., have been found liable for violations of reasonable accommodation protections. So it's important to know that really, no matter your role in the housing industry, this is something that's going to apply to you. So we have one thing. We know what a reasonable accommodation is. It's a change to a policy or procedure for someone with a disability to access, enjoy services and programs related to housing. Now, who is considered to have a disability? We see here our first bullet says individuals with a physical or mental impairment that substantially limits one or more major life activities. But also we're talking about individuals who are regarded as having such, which means they're treated as having such, and also individuals with a record of such an impairment. A brief list of examples of impairments include those that limit mobility, speech, and hearing. So obviously someone with who uses a wheelchair or a walker to get around, someone who is deaf or hard of hearing, deaf or has a speech impediment. Obviously deaf and hard of hearing are closely linked, so I just want to separate those. But I do want to note that some exclusions from that definition are juvenile offenders, sex offenders, and individuals currently abusing illegal or controlled substances. Also, those who pose a direct threat to the safety of others or cause substantial damage to property are excluded from being able to claim disability in terms of requesting a reasonable accommodation. The other thing I want to notice about this is that a disability is going to look different for multiple people, and the need for an accommodation or the accommodation requested could be very different for two people with the same disability or the same impairment. And so that's important to understand, because you should not have a policy that says if someone has this type of impairment, this type of disability, then this is what we will do for them. Really, what's going to guide you in determining what accommodation you make is going to start with the individual's request. So they're going to come and say, because of this impairment, I'm asking you to do this thing for me. And that's really what you're going to judge. You're not going to, yes, you're going to consider alternatives in some situations, but you shouldn't say you can, because based on your disability, you have these different options. You really want to cater your response each and every time to the individual, regardless of something that you've done in the past for someone with a similar disability. So, quick, a few examples of reasonable accommodations that I'm sure many of you are familiar with. Putting forms in large print, allowing for a sign language interpreter, mailing forms instead of having folks bring them physically into the office. If you're in a program where you certify tenants, then this could apply to you. Approving a larger voucher size at PHAs for necessary living aids or medical equipment. Reasonable modification is the second part of this. So an accommodation is a change in policies and procedures. A modification is a change to an existing premises. I have a door lever here instead of a door knob. That's an easy example for someone who has difficulty grasping and turning a knob because of a disability. Now, one important thing with modifications is, depending on the type of housing that you're either managing or the type of housing that you own, the tenant's likely responsible for the cost of changes, modifications to the property, and also responsible to return the property back to its original condition at the end of their tenancy, if this is something that you as the owner or manager desire based on the modification that was made. Now, let's say I own a single family home, and the tenant has put in a ramp to get up to the front door instead of having to use the steps. Based on my community, based on the appearance, based on, you know, what the ramp kind of replaced, did it take away a yard or something like that, I might ask the tenant to remove that at the end of tenancy, or I might say, you know what, this is a really great kind of amenity for this home, and so I'm going to let it stay there, so the tenant is free from the obligation to having to take it out when they leave. So I talked about reasonable accommodations being mandatory. They're mandatory. They're required if they meet certain conditions. So here we have this test of necessary and reasonable. How do we know if a reasonable accommodation request is necessary? Well, we have to identify a relationship between the request and the individual's disability. There has to be a connection there. I can't make a request for, if we go back to the example of mobility. If I have a mobility impairment, that affects only how I get around, it would make no sense for me to request that forms be put in large print. So that's an example that I gave you before. Now, obviously, if I'm a manager of a property and I have forms in large print, or I can change the print easily on forms and someone makes that request, that's something that's pretty simple, that's almost no cost, really. And so it's something that you might approve without even going through a whole process for a reasonable accommodation request. But the point is that there has to be a connection between the disability and the requested accommodation. Also, the individual who's making the request or who the request is made on behalf of has to have an actual disability. That almost goes without saying, right? But it doesn't, so I have to say it. Second, here we have reasonable. So we want to make sure that the accommodation doesn't cause an undue burden, either financially or administratively. So let's look at, is there a cost associated? The example I gave with the large print forms, usually, like I said, there's going to be a very, very minimal cost to transform a form from, let's say, 12-point font to 24-point font. Yeah, it's going to, cost you a little bit of time and some extra paper, but the cost is generally going to be quite minimal, no matter almost the size of the program or how many units you own and things like that. But will the change negatively impact our ability to serve others? So what's it going to cost you administratively? And then if it is a burden, are there other ways that we can meet the family's needs that are less burdensome to us as a program, but also still satisfy the need of the individual with the disability? Those are some things to consider. As I said, requests, as I mentioned, I should say, a request can come from anybody. The subject of the request, however, has to be a disabled individual for the accommodation to meet that standard. So the individual, the tenant themselves can make the request, or applicant if it's an applicant, or a family member, friend, caseworker, pastor, rabbi, so on and so forth. Anyone can make a request on behalf of an individual. You can obtain, if needed, you can obtain information needed to evaluate the necessity of the accommodation. Now, the same thing goes with a disability. You can request information to verify the presence of a disability. Now, if the disability is obvious, if an individual says, I have a mobility impairment and they're using a walker or in a wheelchair, then you cannot request further verification because it's obvious. Or if you know through some other means that the individual has the disability that they say, you also cannot ask for further verification. Again, if it's obvious, or if through some means you have prior knowledge, you cannot ask for that verification. Any documentation that you obtain should be limited to what's necessary to determine that a disability exists and that the accommodation is needed in response to that disability. You also can't require for the verification to come from a certain source. It has to be, sure, a legitimate source. You don't want, for instance, someone going and, just going to another resident saying, hey, could you write this letter for me? This is my issue. Could you just write this up for me? Yeah, you want it to be someone with some kind of objective knowledge of the individual, of the situation, the condition, the accommodation. Again, a case or social worker. Again, a health aide. So it doesn't only have to be a doctor, is what I'm trying to get at. The request can be made at any time. It does not have to say reasonable accommodation. It can be oral, it can be in writing, it can be an email, it can be on the back of a napkin. They can send a message in a bottle, just to be really dramatic. You can make preferred forms available, but you cannot mandate their use. That's really important. So most, if it's an PHA or some other kind of agency that, especially if you deal regularly with folks with disabilities, you probably already have a policy in place and forms to go with that. If someone declines to fill those out or makes a request in another way, if they shoot you an email or make a phone call, if you have the form and you want it used, and someone on the back end, on your end, can notate the request on the form, that's fine. But you cannot say, well, because you didn't use our form, we're not going to consider this, or we're going to deny your request. And so again, I just want to remind you, when you're talking about approving requests, these are some things that you really want to consider. Again, you want to make sure there's a connection between the disability and the accommodation, but you don't also want to make it too hard of a process for someone, because it's, it just eats up your time and their time. It makes them frustrated. It can kind of create bad blood, and you could send them on their way to, filing a complaint against you because you were perceived to either drag your feet or be non-responsive or hostile to the request. I want to move ahead to a subset of reasonable accommodations, which has grown in popularity, I think, which is assistance animals. So earlier I talked about a type of reasonable accommodation where you might, if it's a housing authority, for instance, you can allow someone to have a larger voucher size for a live-in aid or for medical equipment. We treat assistance animals the same way we treat medical equipment or a live-in aid, not in the sense that they get an extra bedroom for a seeing eye dog, but that it's the same way a live-in aid is not a household member, an assistance animal is not a pet. So assistance animals are those that help with physical tasks or provide emotional support for individuals with disabilities. Landlords, you have to allow an exception for your pet policy for disabled persons who need or desire to live with an assistance animal. Yes, there are, it's not a blanket yes, and we'll get into that in a little bit, but I do want to say that, again, we do not look at assistance animals the same way we look at pets. Now you see that last bullet there, unless doing so would be a threat to the health and safety of others or cause substantial physical damage. Now, one of the things that we'll talk about is how we judge that threat, and that'll be in the next slide. But for right now, I want to focus on how you consider a request for an assistance animal if an individual is requesting an exception to your policy. Having a disability does not entitle someone to having an assistance animal, okay? What that means is that there still must be a connection between the task performed by the animal and the individual's disability. And the same way we talked about with any other accommodation, you can request documentation. Now here we're talking about health and safety, safety of individuals and the integrity of your property. That has to be on a case-by-case basis. I'm going to read the second bullet here. Breed, weight, and size limitations cannot be applied to an assistance animal, which means you cannot say only dogs can be assistance animals, or no hamsters can be assistance animals, or a type of a dog, or a cat, or so on and so forth. It's really important that owners and managers really have an open mind about assistance animals, about what types of animals can perform tasks, because you would really be surprised. I was doing a training in the fall and someone mentioned a chicken as an assistance animal, because when we get into the, well, I don't know about physical tasks, but when we get into the area of emotional support, you know, an individual doesn't need to get emotional support from any type of animal specifically. Now, how do we evaluate threats to safety or to property damage? Really, it's on a case-by-case basis, as I said, as it says here. So what that means is that if a specific animal has been shown to be a threat to others, or if a specific, not type of animal, meaning that dog, that cockapoo, or that, you know, golden retriever has attacked someone, or has threatened someone, or has shown to be unable to be controlled and chews up, you know, walls, or whatever it is, then we can talk about denying that animal. But generally speaking, unless, you know, it's obviously if someone's trying to bring a wild, undomesticated lion into your property, you know, we're not going to expect you to wait and see how the lion behaves. But for most domesticated animals, we do need to see behavior from a specific animal in order for denial to be acceptable under the assistance animal clause of reasonable accommodations. So that's a lot. One of the things I want to mention, so we're moving forward to the criminal records section. One of the things I forgot to mention at the top is two things. One, we do fair housing trainings. I do fair housing trainings. Quadell provides them. You can request a custom training. And so while we're going more in depth into these five, I believe, areas today, we don't have the time to, you know, provide you with all the policies, procedures, details of every single area. And so if you're interested, if your organization is interested, please visit quadell.com/training for more information on how to request the training. And when I do trainings, we do case studies, we do group activities, and we really use practical examples to show individuals this is what can happen. This is not a far-fetched idea. I just gave the idea about a lion. To my knowledge, that's a far-fetched idea. Because you got to first procure, you know, a lion from the wild and, you know, ship it somewhere. So in my mind, that's a far-fetched idea, but we go over real-life situations that individuals are likely to encounter, even if they do seem a little bit strange. So I do want to mention that to you today. Again, if you have any questions about specific areas, you can ask those as well in the question pane. So moving on to criminal records. This is the first concept that we'll talk about today that places disparate impact front and center. And what we're talking about is using someone's criminal history to make a decision, an adverse decision, a housing decision. So about an application, denying their application, or some other things. And so I had to release guidance about this last year, about how using criminal records and how to do it safely, as to not just have a discriminatory effect. And that's really your goal. So considering criminal history and making housing decisions is allowable, but you have to be careful and purposeful. So if your policy, if it's, you know, we don't allow anyone to rent here if they have a criminal conviction, or if they have a criminal conviction in the last 10 years, or, you know, something like that. If you have a broad policy like that, it can easily have discriminatory effects, and the HUD guidance lays out why that is, and it talks about disproportionate arrests and incarcerations of certain protected classes dealing with race, sometimes national origin. So it talks about how a blanket policy, especially if you consider your particular community, a blanket policy could severely, disproportionately, adversely affect protected classes. So think about your legitimate aims in considering criminal records. Most likely, we're thinking about the protection of people and property. You obviously don't want to rent to someone who's going to be a threat to the safety of others, or who's going to be a who's going to cause damage to a building, or who's going to engage in unwanted criminal activity. Obviously, if you could screen out anybody who's going to be a problem tenant, you would do that. That's obviously also not possible. So there are, different things that we do to try to get at who's going to be a good tenant, who's going to be a good member of this community, and who is not. And so it's understandable why owners and managers use criminal records. However, you have to have evidence that your policy does what you say you intended to do. And so HUD has been, again, this is just guidance, but they're very clear that you can't institute a blanket policy because that's what your organization does and has done for 15 or 20 years. You have to be able to say, our policy of excluding individuals, these types of criminal records, is effective in these ways. You have to have some kind of data to back up your policy. Assumptions that any individual with an arrest or a conviction record poses a greater risk than an individual without such a record is not sufficient to satisfy that burden. So you cannot make an assumption that, as much as you want to, you cannot make the assumption that says, well, if this individual has a criminal record, then obviously they are more of a threat than someone else. HUD is saying that's a no-go. Differently, but kind of under the same umbrella, is arrest history. So you can look at conviction history, which is the example I gave, convictions, lifetime convictions, or convictions in the last 10 years, which are really broad policies which can have harmful and discriminatory effects. But using arrest records is really even worse. And so that last bullet there is a quote from the U.S. Supreme Court. And HUD uses this quote to support its guidance that an arrest history does not accurately describe one's involvement in criminal conduct that threatens residents and property. And that's because arrest records do not typically show whether an individual is prosecuted and the result of such prosecution. So saying, well, if you have an arrest in the last 3 years for X, Y, or Z, then we're going to deny you admission, or that can be cause for eviction. HUD is saying that's too broad of a policy. The potential for harm are too great, and you're likely going towards discriminatory effects and disparate impact. And so what the Supreme Court says about arrests is that an arrest shows nothing more than that someone probably suspected the person apprehended of an offense, which means that if I was to be arrested, then the only thing you can really glean from that is that a police officer suspected me of doing something illegal. That doesn't mean I did it. That doesn't mean I was in the same state when it occurred, so on and so forth. So using arrest records to make decisions is really too broad a brush in terms of having a policy to protect the residents and the property in your community. However, if you're using the conviction history, you also are required to differentiate between criminal conduct that puts your residents and property at risk and the criminal conduct that doesn't, which means, again, when I talked about data, so you want to make sure that you know that these types of conduct that are engaged in can be harmful. The individuals that engage in this conduct can be harmful versus individuals that engage in other criminal conduct. So for instance, an easy example is, say, writing bad checks. Obviously, you don't want someone writing you bad checks, but denying admissions to someone for writing bad checks, for a conviction, for past, let's say 2 or 3 past convictions, does not mean that that individual is going to pose a threat to the safety of others or to your property. You might have a policy that says we only accept money orders or cash or certified checks anyway. There's plenty of places that don't accept personal checks. So that's something that you really have to be careful with, is making sure that that conduct is actually conduct that indicates the individual will be threatening. The guidance, honestly, it's really tricky to try to implement this because it's only guidance. It's not a regulation. They're not instructions. But what HUD wants people to do is to really be careful about how they institute policies. But lastly, what's really important is that regardless of your policy, you have to apply it equally to all individuals. Okay. So moving along to our next subject is the Violence Against Women Act. This is really a far-ranging subject. Depending on your type of property, what applies and what doesn't is going to vary. And so we'll begin by talking about covered properties, and then we'll talk about some nuisance ordinances, which apply to mostly to localities, but also private owners, and covered properties still are going to be affected by that. So briefly, VAWA was initially signed into law in '94. VAWA did not address, originally it did not address protection and housing programs. Even though it's called the Violence Against Women Act, you should know that it applies to all victims of domestic violence, irrespective of their gender. Men, for instance, have the same rights and protections as women when it comes to VAWA. In 2005, which again, if VAWA went into effect in '94, this was 11 years after its enactment, housing programs were first included as covered programs. The HCV program, Project-Based Voucher Program, Public Housing, Supportive Housing Program for the Homeless. In 2013, many other HUD programs, HUD-funded or assisted programs were included. You see Section 236, multifamily rental housing, 202, 811, the Housing Trust Fund, and tax credit programs. So there's a number of programs that are now included. Again, this does not include private owners and landlords. So, what are the protections for tenants? I'm referencing really the 2013 Act, which enhanced protections and options for victims of domestic violence, dating violence, sexual assault, and stalking. And here we have three topics: emergency transfer plans, bifurcation of lease, and reasonable time. So in addition to protecting tenants, there are also some protections for owners. So owners can be wary of, when a tenant is protected, an owner doesn't want to infringe on a tenant's rights, but still has to maintain whatever business they're engaged in and assure the safety of their property and things of that nature. So housing providers have the right to comply with court orders that deal with the right of access or control over property and the distribution or possession of property among members of a household. So if you get a court order, VAWA says an owner can't be held liable for complying with that court order. Furthermore, an individual or a household can still be evicted for a violation of the lease that's not related to a tenant's status as a victim. Housing providers need to treat the same way you got to treat people of different genders the same way, or different family compositions the same way, or different races the same way. You cannot also have a different standard for victims of domestic violence than other tenants. So some other things that VAWA did in 2013 is instituted notification requirements. So all covered housing providers must provide to all applicants and to all tenants the notice of occupancy rights and the certification form that's described in VAWA. HUD has model forms that you can customize. Here we see the 5380 and the 5382. You can customize those with your organization's contact information and things like that, and provide those to tenants and applicants. Applicants have to be notified at move-in or at the initial certification or at notice of rejection. So those are new folks. That's to ensure that everyone coming in is now going to be provided with this information. And we're talking about the notice came out last year, and so there's a 12-month period that ends at the end of this year in December 2017. Everyone in a program needs to receive notification during that time. And so this is what we're talking about here. If they have a annual certification during this calendar year, or if they're notified that their assistance is being terminated, or that their tenancy is being terminated, they must be notified at one of those 3 points this year. All tenants must receive notice. I'm emphasizing this because I don't want anyone saying, well, I didn't know that. All tenants must receive, current tenants must receive notice by December 16 of 2017. And that goes back to tenants that were in the property as of December 16, 2016. So hopefully if you had anyone that was terminated, their assistance or tenancy was terminated, or they were recertified between now and December, hopefully they were already notified. So by June 14th, which is I guess about a month away, or if not less than a month away, actually, covered properties must be in compliance with the rule in respect to having an emergency transfer plan in effect and all record keeping and reporting requirements. This is one of the areas that's really, we can really get in depth about emergency transfer plans and what's required and the reporting requirements. But on a webinar, on an hour webinar, I don't have time to do that. So if you were to have a custom training and you were to want information specifically about VAWA to be covered, then we will go in depth in that. But I think the largest takeaway for anyone on this webinar today is to review your tenant selection plan, review your policies, your ACOP and admin plan if you're a PHA. Ensure that VAWA policies are addressed and your wait list and eligibility, admissions, transfers, denials of assistance, record keeping. A big thing here is confidentiality. The medical records, I think, in a lot of places receive less protection than VAWA records, records of domestic violence and abuse. And it's not to say that medical records aren't important. Those have to be kept extremely confidential as well. But with records pertaining to domestic violence, stalking, so on and so forth, those are typically and should always be treated with the maximum amount of confidentiality. Limit who can see those records, where they can be accessed, in order to protect the victims from further victimization. It's very important. The last two things I want to mention, were really the last thing I want to mention about VAWA, is what I talked about at the top, which was local nuisance ordinances. So communities have often had kind of like efforts to reduce crime and nuisances in communities, and so they might say, you know, if you're causing, you know, if you're causing complaints, if you're causing police to be called out, if you're causing, you know, emergency medical providers to be called out, we're going to consider that a nuisance, and there are going to be penalties for repeat violations. And so HUD made it really clear that if domestic violence is considered a nuisance, regardless of whether the individual whose conduct is being targeted is the victim or the perpetrator, this can lead to discriminatory action. So this goes back to disparate impact. When we look at domestic violence, we know that intuitively, and it's borne out in the data, that 85% of victims of domestic violence are women, and women are 5 times more likely than men to be victims of domestic violence. And so if I'm saying, if you get the police call 3 times for a domestic violence incident, you're getting evicted, and it doesn't matter to me as the owner, or it doesn't matter to me as the city council whether you're the victim or the perpetrator, then I'm going to be subjecting victims to the same harsh treatment that I am perpetrators. And that's not only unfair, but it can be a discriminatory effect as well. So we don't punish victims of violence for being victims, okay? HUD had, in I think 2011 maybe, the Fair Housing Office released some guidance, and this last bullet here was a quote from that. And so take a minute to read that. In addition to women being, like I said, 85% of victims, 5 times more likely to be victims, other protected classes such as African Americans and Native Americans are disproportionately victimized by intimate partners. Also women of certain national origins and immigrant groups. And so you see you've got gender, you've got race, you've got national origin, and all these kind of things come together when we look at domestic violence and how we treat domestic violence victims. Okay, so we want to be very careful about that. So the last subject area that I want to go over today in this, again, this more in-depth training, actually the second to last, is quid pro quo and hostile environment harassment. HUD released a rule late last year about this because the Fair Housing Act also prohibits harassment of individuals seeking to enjoy their rights to fair housing or helping others enjoy those rights. And so this rule really gets to, it kind of piggybacks on VAWA, sexual harassment, hostile environment harassment, and you see the definitions here. Quid pro quo is this for that. So I make a request or a demand of you that's unwelcome and condition assistance, condition services, condition access on your response. Hostile environment harassment, if I subject someone to unwelcome conduct that interferes with their ability to enjoy housing, enjoy services, enjoy the premises, that's hostile environment harassment. Conduct comes in lots of different ways, and it's important to understand that. Conduct only, the rule makes it clear that the totality of the circumstances, the context, the number of times it's happened, how it's happened, those will all be considered in determining whether the standard is met. But it's important to know that if it happens once, it can be considered discrimination. This rule really does put a burden on administrators and managers to monitor program staff and respond effectively to complaints because of liability. So we have 2 types of liability here: direct liability, and we also have vicarious liability. So direct liability is when I either did something, so it's my conduct, or I didn't end conduct that I was aware of by an employee of mine, or I didn't end conduct by a third party. If I knew about it or should have known about it and had the power to correct it, I can be held, or you can be, as an agent, as a manager, an owner, you can be held liable for that kind of harassment. So this is what I'm talking about when I talk about the burden to respond effectively, to train your staff, because it can go, if it's, your maintenance individual, the maintenance supervisor can be held responsible, the building manager can be held responsible, and potentially the owner. And so the liability here, you got to be really aware of. Vicarious liability. This is regardless of whether, as the owner or manager, regardless of whether I knew or should have known of the conduct, it can be considered discriminatory, and I can be held liable for those practices by my agents or employees. So we have direct liability, where you knew of it or should have known of it and you had the power to do something, and vicarious liability, which really captures everybody else. If you knew about it or didn't know about it, those individuals can also be held responsible. So what's prohibited? Conditioning the availability, price, qualifications, or policies on someone's response to harassment. This is the quid pro quo that I described. Subjecting a person to harassment on the basis of their status in a protected class, including gender. So sexual harassment, because that's treating 2 people differently. If I would harass a man but not a woman, or a woman but not a man, that's treating people differently because of their status in a protected class. Retaliating against someone who reports discriminatory conduct, that is harassment and is prohibited. Okay? So as I said before, when I was talking about the liability and talking about the burden on owners and managers, everyone from the floor sweeper to the accountant is responsible for ensuring fair housing requirements are followed with respect to their job. You're responsible to be a learner. You're responsible to be aware. You're responsible to communicate questionable situations with your supervisor. Supervisors, you are responsible to ensure your staff is trained. Again, the rule makes it very clear that liability can be far-reaching. And the rule, again, it was published last October, so I'm not aware of any cases that have been brought, any complaints that have been brought in response to that or under that rule. But you don't want to be the first or obviously the second or third. But what I'm saying is you don't want to be someone who ends up being the test case to see how far HUD or the courts are willing to interpret that regulation. So the last bit of advice I want to give as we close out is how to handle discrimination complaints. Every housing provider should have a policy on how to handle discrimination complaints because they're going to come. It's like, you know, the weather. We know at some point it's going to rain, and you don't want to be caught rushing off to work one day, looking out your window, seeing it's raining, and you don't have an umbrella. So let your company policy be your umbrella. Make sure your staff is trained on your company policy. HUD is a great place to tell people to file complaints. I had this happen recently where an individual had what she thought was a fair housing complaint. She thought she was being treated differently because of her membership in a protected class. She thought that she was being harassed. In regards to what I thought about it, the first thing I instructed her to do was say, you can make a complaint to HUD. And I printed out the phone number, the information where she could do it online, she could call in, whatever she wanted to do. I wanted to make sure that she knew that I was saying this is a way that you can report your complaint. But also, obviously, we take the information in as well, and we deal with it, we investigate. But now, you know, here on the webinar, just as an example, it didn't seem like it was harassment to me, or the conduct didn't seem to be connected in any way to a protected class or a fair housing violation, regardless of whether it happened or not. But that was something I didn't share. Not only I didn't share that with her, but I didn't share that with anyone else. I'm sharing it with you all now just as a learning experience. But I wouldn't even go back to a colleague and say, this is what happened, this is what was reported, but I don't think it was anything. I wouldn't even do that. Okay? As I told you, having written policies is the first thing that you want to do. You want to have policies and procedures that are written and ironclad. This has to do with admissions, eligibility, evictions, and how to handle complaints. On your policy, make sure your staff is trained. Make sure your staff is following policy. Anytime anyone takes an action against established policy, against established policy, you're creating a trail that can show favoritism. The flip side of favoritism, if we're thinking about a coin, one side is favoritism, one side is doing someone a favor, the other side of that is discrimination. Because if I'm doing favors for somebody or some people, but not others, depending on who those groups of individuals are, that could be found to be discriminatory, regardless of if I had that desire or not. An example I often give to people is with maintenance workers, if they're choosing how to prioritize their work orders, that could reveal, even if they didn't intend it, that could reveal a discriminatory pattern. So you have to have policies for all activities that staff members undertake. Listen to applicants and residents. So don't be quick to deny requests from an applicant or resident. That goes back to reasonable accommodations, reasonable modifications, and other things. Not only is this good customer service, but it can also avoid the headache of a fair housing investigation. The last thing you want to do is, or the second to last thing I want you to do is retain applications and records of decisions along with rationale. This includes, if you're in an apartment building, if you had a prospective renter, which units did you show that individual? If you offered favorable terms, such as if there was a rent special, make sure that's documented, because you don't want it to come back and say, well, this person, these people got these lower rents and I didn't get that. You want to know, you want to be able to substantiate any decisions that are made. Lastly, be prepared to investigate, be prepared to admit wrongs, and be prepared to take corrective action. Okay, I was watching an episode last night of a show called The Profit, and this guy goes around and helps struggling businesses. He invests money, and he found out that his is a restaurant. The general manager had a personal relationship off and on with an employee. That employee was later at some point fired. It's not clear if it was in connection with the relationship souring or what, but that investor took decisive action, terminated the employment of the manager, and moved forward. And the reason such strong action has to be taken is because if not, you're opening yourself to a world of trouble. Yes, we're talking about employment situation in the example I gave, but a lot of the regulations that pertain to discrimination in housing mirror those in employment. So it's a really relevant field. But also, I'm letting you know, just because you want to be able to take decisive action and not be afraid to admit when you are wrong and to move on from those incidents. Okay, so I have covered those 5 topics, and you can again submit questions. What I will do as people are considering submitting questions, I want to point out 2 things. 1, here are some resources for more information. The National Fair Housing Alliance, HUD's Office of Fair Housing and Equal Opportunity, and I have a link there to the Fair Housing Act. You can also Google Fair Housing Act, and you can read it if you are so inclined. FEHO, they have a page of all kinds of regulations and useful information as well. Of course, I have to mention Quadel is a great resource. We provide certification trainings, including the upcoming one in Philadelphia, which is here. We can also design custom trainings for your organization that are catered to your state and local issues. We also have a host of other training and consulting services that I talked about that you can visit our website. Beyond that, if for further education, there are fair housing offices, fair housing advocacy groups, almost guaranteed to be wherever you are, so you can look those up with a Google search. If you're in Detroit, Fair Housing Group Detroit. If you're in San Francisco, Fair Housing Group San Francisco. Just do a Google search of that, and you will be able to find out some information about what's going on in your community. Okay, so as I said, I have reached the end of the material. Again, feel free to ask any questions. I will leave this open and leave the webinar going for a while if people have questions. Otherwise, I thank you for attending. I thank you for your attention, and I hope that you'll reach out to Quadel for your training needs, and I'll have the opportunity to work with your organization wherever you are. Thank you very much, and have a great afternoon. All right. So we have our first question for those who are hanging around. Is it illegal to state in the tenant selection plan that the applicant can be denied if any felonies or drug charge convictions on record in the past 7 years? So strictly speaking, no, it is not illegal. The guidance that I mentioned about criminal records, again, is only guidance from HUD. So this isn't a law. This isn't a regulation at this point. It's just guidance. So think of it really as a helpful hint. Now, what HUD is saying in that guidance is that your policy of denying any applicant if they have any felony or drug charge conviction in the past 7 years that could be construed to be too broad. So what HUD wants to know is, how are you able to make the connection between any felony or any drug charge in the past 7 years and current resident safety or protecting the physical building? HUD is going to say, I don't have a number of how many felonies there are or how many possible drug charges there are, but let me give you one example of someone who 4 years ago was convicted of illegally obtaining prescription drugs. Let's say they had an opiate addiction, which we're all talking about now, and so they illegally obtained some oxycodone or something else, and they were convicted of that 4 years ago. If they come to you today and, that was 4 years ago, you have to be able to answer the question of how does that drug conviction 4 years ago for prescription drugs, how does that affect whether they will be a threat to other residents today going forward? I think that while those kinds of policies are common, HUD will probably say it's hard to make that connection. And if you can't make that connection, then you're just preventing potentially a large class of people from accessing housing. And HUD, based on the guidance that was issued, would frown on that policy. Now, the opposite is saying someone with a violent conviction in the last year, or a stalking of, say, residents and a rental property, or something that can show that this individual that the individuals who are guilty, who have been found guilty of these charges, are shown to be threats to the safety of others they live close to, then you can make a case that way. But I think based on guidance from HUD, that blanket policy could be considered to be too broad. So you really want to take a look at your policy and figure out how you can be really specific and get to the issue of safety. This is a really tricky area because most complexes, most owners and managers aren't necessarily going to have the ability to kind of do the types of research and have the kind of insight into criminal justice policies and data that's necessary to make these judgments. So to be honest, I think you probably want to engage with HUD or engage with other fair housing providers about this issue and get guidance from them about how to formulate your policies. Obviously, for all of your housing policy questions, Quadell is a great resource. But to answer your question again, no, I wouldn't say illegal. I would say that you could be on, I don't know if I want to say thin ice, but it could be a little icy out there on that ledge. Thank you for that great question. Does anyone else have a question? I'm going to give it a couple more minutes, and if we don't get anything in, then I'll end the webinar. But again, you see our contact information there if you want to follow up. Also, here's a great question, and it was one that was asked in the last webinar that I should have answered at the top of this one, about a certificate for this webinar. So our certifications are for courses, and so like I mentioned a couple of times, there was, like, if we talk about reasonable accommodations, if we're talking about VAWA, there's so much that I could not cover in an hour webinar, that it would not be possible to provide a reliable certification for this. This was really kind of an overview, a refresher for individuals. And so for certification, for an actual certificate, you would have to attend one of our certificate courses, which can be for a day or longer, depending on the material that you want covered. But no, today you can, you might be able to say that you attended this this webinar, but we are not giving out certificates for this. Okay, well, it is now 10 after 3, and it's been about 10 minutes. So I'm going to end the webinar again. For those who are still here, thank you. Thank you. Please look up Quadell, look up our website, look up our offerings for training, consulting, management services, and I hope you have a great day.